यूपी Panchayat Raj Act 2014 is valid, empowers members of the Gram Panchayat to remove the Pradhan of Gram Sabha for the motion for no confidence. It is an unconstitutional, it's infringing democracy or Article 14. Ram Belli with the district Panchayat Raja Durai. Pension by around years interpretation of the rules, it is a pensionary benefit is granted to someone. It would not mean that the same mistake would be perpetuated by the direction of the court. Union of India versus Ramesh Kumar. Decision of D.S. Nakara versus Union of India can be evoked so it to give a liberation for pension to who has already retired period to the liberation. State of Rajasthan versus Prem Raj. But it cannot be applied irrespective of the fact of the case. KL Rathi versus Union of India. Retrospective reduction of pension that has already become payable to employees is unreasonable and void. Chairman Railway Board versus C.R. Rangatharmashi. Principles of national justice. So hearing the party's application of a mind and recording the reasonable decision on the basis of elements of natural justice. The educating process essential to have been conscious with the principle of natural justice, including doctrine of Adi Altrum Patrum, Monoharan Manikoro Anchuli, the state of Maharashtra. This court is not bound to issue notice to complain and hear him in relation to release the person accused as a bailable offence such as defamation. Court is not bound to issue notice to complaint as to hear its relation to release of a person accused of bailable offence such as defamation. The cancellation of bail on the ground that the complaint was not heard is not proper. Rasikal versus Kishore Kanchan Wadhauri. A person cannot be allowed to raise the plea of violation of principle of natural justice who refused to appear in spite of despite of the notice of appearance. P. Manon Sundaram, Vice President of ICA. Non-speaking of order is supposed to be principle of natural justice. Arjun Yadav, State of Jharkhand. The cross-examination is an illegal part of the principle of natural justice. Ayya Bukam Noor Khan Patan, State of Maharashtra. National justice of no strict observation. In a situation of national security, one cannot insist the strict observance of principle of natural justice. Ex-Army Protection Service Union of India. In situation of national security, one cannot insist for strict observance of principle of national justice. From procedure of discrimination, they have Article 14 forbids discrimination in matter of procedure. State of West Bengal versus Anwar Ali. State of Odisha versus Derindraka Das. Kati Rani Rawat versus State of Shaurasa. Special Court Bills versus Chaurab Union of India. Here is the courts are not concerned with the validity of Parent Act, but with the mode of exercise and power. Therefore, flexibility. The Article 14 was built flexible to allow the reasonable classification pass on the objective basis. Premium granite is the state of Tamil Nadu. Grant in aid. Non-existence of the grant in aid in state of non-government law college, but grant of such benefits to non-government law college with the facilitating parent discrimination. Parent discrimination. State of Maharashtra versus Manubai Prajaji Vashi. The court could decide a challenge of legality in order to allotment of land by the government on the basis of material available in the High Court and examine the challenge not on the basis of what happens in the future. Humanity is the state of West Bengal. Granting largeness, large EC. The state of government can restrict the number of distillery license in particular state by 2, but it can also grant a third license in a particular district as well as application cannot be claim a license a matter of right. State of Kerala versus Kandat distilleries. The government has to act fairly and without any semblance of discrimination in a matter of granting a large EC. It cannot act arbitrarily and the matter which could be benefit the private matter. Humanity is the state of West Bengal air. Granting license, it is not necessary. The state government for granting license for establishing new industry which adverse the invite offer of putting in a new industry in state. It is entitled to negotiate with those who comes up with an offer to set up a new industry. State of Kerala versus Kandat distilleries. Illegal act. Equality clause cannot be applied by legitimate illegal action. Yekta Shakti Foundation, government of NCT of Delhi. Illegality cannot be perpetuated where an unauthorized construction of an appellant is violating the building bylaws and terms and conditions is a lease deed prejudicially affecting the proper planning in the industrial area. He cannot claim that benefit extended to others, though illegal should be extended to him. This article of section Article 14 provides a positive equality and not a negative equality. Visual properties, the state of Uttar Pradesh. Interpretation. There is a no discrimination where owing to a wrong interpretation of or some products are exempt. There is no discrimination where owing to a wrong interpretation some products are exempt interpretation. Land acquisition. The classifications ought to be made to determine the amount of compensation for acquisition of a land under the Defense of Indian Act. The Land Acquisition Act 1984 is reasonable and valid. This classification is found in intellectual differentia and has a rational relation with the object sought to be achieved by the legislation industry. So the said classification is found to be intellectual differentia and national relation to the object should be achieved by the legislation of the Union of India, which is Chanjura. Land ceiling. Section 4, subclass 7 of Urban Land Ceiling Regulation 1976. It is not constitutional. It is not unconstitutional. On the ground, it is made certain special provision regarding Hindu undivided family. Such a family is not a person, and it's not treated as a single unit for the purpose of ceiling and a ceiling limit. Under Section 4, Class 7, each individual member, major or minor, has a separate ceiling. Pratima Paul was competent authority. Legitimate expectation. There is a legitimate expectation to get permission to run a minority institution. Secretary Canonor District Muslim Education Association, Kanpur, State of Kerala. Premium which is stages of service available to parents. Premium statue of service available to the patient by doctor, raising a legitimate expectation. Malya Kumar Gangulu, which is Shukumar Mukherjee. Limitation. Broadly speaking, the judicial decision interpreting the Article 14 is recognizing the paramount nature of fundamental rights. The recognizing the needs of consideration reality has been legitimate. It is often stated that the equality before the law guaranteed by the first part of Article 14 is a negative concept. The second part is more a positive concept. The neither part of the Act is above the recognition of the expectation and qualification of neither part of the article is above recognition of expectation and qualifications. That's why the first part is which is mentioned by the DC Law of Constitution 9th edition page 201. The second corollary is a rule of law which rule on special privilege for the governors, also member of parliament and state legislation. Moreover, some of the provisions interpreted to result in certain elements of discrimination. For example, liability of the state is taught even today in India is not necessarily the same as the liability of a private employee. According to the current today, no suit lies against the government for inquiring in the course of exercising a sovereign function of government. State of Rajasthan, Vidyavati. Shyam Sundar, State of Rajasthan. Mala Fidi. Action taken by the state in undue haste may be held to be mala fide. Interpreting Singh Holon is the state of Punjab. In decision is taken bona fide of the public interest. Mere fact that decision was ultimately proven to be wrong would be itself not a ground to hold the decision on the mala fide. Arun Kumar Agarwal is Union of India. When the allegation of mala fide was made, the person against whom the same is leveled need to be implemented at the party in the proceeding to enable them to answer the charge. Ratnagiri guesses powerless. If the termination is responsible for mala fide, it will be quashed immediately. Jayalalitha of State of Karnataka. Newspaper. The state cannot be view equality doctrine contained Article 14. This Constitution of India sought with theory take it or leave it. The bargaining power of state and the newspaper is matter release of advertisement is unequal, and any injustice condition thrust upon the state would attract the wrath of Article 14. Hindustan Times, State of Uttar Pradesh. Panchayat removal of members. UP Panchayat Raj Act 1937 Section 14 is valid. It is empower member of the Gram Panchayat to remove Panchayat Gram Sabha by a motion of no contents. It is unconstitutional and inferring the democracy of Article 14. Rambili District Panchayat. Rajasthani language. Non-inclusion of Rajasthani language in the 8th schedule of Constitution does not violate the Article 14. Such policy matter have to be left to the state. The judicial interference in the uncalled in the absence of malfidis. Kanhaiya Lal C. Thai, Union of India. Reasonable restriction. The limited power of expectation, exemption from the operation of noise rules granted by the central government to exercise the statutory power is not unreasonable. The power to grant exemption is a reasonable restriction placed in the public interest. Forum Prevention of Environmental Sound Pollution versus Union of India. Reasonableness. The important consequence of the right to equality is the element of reasonableness. Classification as unreasonable is open to challenge, and the extent of policy of legislation is open to judicial view. In the aspect of the illustrated, inter alia following decisions. Northern Indian Carrier is the state of Punjab. New Money Chowki Specialist is based Mills Company Municipal Corporation of City of Ahmad, and Nagpur Improvement Trust is with Vithal Rao, National Council of Teacher Education with Sri Shayam Shakita Prakashan Chancham. Classification. The valid classification is a true valid discrimination. The Article 16 permits a valid classification. However, a very classification must be based on or just objection result to be achieved by the very objective purpose to choose some differential consideration treatment over others. The classification is valid must necessary to satisfy two tests. Firstly, distinguish rational has been based on the just objective, and secondly, choice of differential set programs and other just a reasonable nexus to objectives sought to be achieved. Test of valid classification may be summarized on the distinction based on the classification found on an intelligent differential. There's a rational relationship which is object sought to be achieved. All the Manipur Petitioner Association of Secretary State of Manipur. The industry which has huge requirement and use of water, they are placed in one district category and class to their own and also differential situated from the residential house. This exists in intellectual differential. The Pepsi Indian Holding is a commission of trade tax Lucknow, where a cutoff date is fixed to categorize one set of employees to favor the consideration of over others. The twin test of valid classification must be necessary to satisfy KT, Retired Official Association State of Tamil Nadu. Its classification is conducive to the function of modern society. It would be conducive. It is certainly reasonable and rational. It is not violating the Article 14 Transport of Dock Workers Union Mumbai Port Trust. Act of repository of the power where legislation, administration, or quasi-judicial open the challenge. It is conflict the constitution of the growing act and the general principle of law of the land, and so is arbitrary to unreasonable for no fair mind. No authority could ever made it. Sri Sitaram Sugar, Union of India. Mere apprehension of order being used against some of the persons, no ground to hold illegal, unconstitutional particulars. Even the legality of constitution was not challenged. Manu Sharma, Union of India. Classification based on the birthmark that's too obligated after integration of the officer coming from a different source as common cadre and category would be wholly unjustified and discrimination. Yes, Shina Guru is state of Tamil Nadu. B. Manmat Reddy, Chandra Prakash Reddy. Relief benefit. A wrong order decision in favor of a particular party does not entitle any other party to claim benefits on the basis of a wrong decision. Basavaraj is a land acquisition officer. Royalty of industries. Government decision is a matter of policy. It's a prima facie based on the plausible relation, rational or generally occurred the code. A certain element of discretion is thus allowed to excise and excuse in Yamma oil extraction, state of Madhya Pradesh. Rule of law. Action of the state as instrumental should not only be fair, legitimate, and above should also be without the affection or aversion. It should neither suggestion of discrimination nor even give an impression of bias, fear of trust, or nepotism. A state of Odisha versus Mamata Mohanty. State of Maharashtra versus Sharang Dakshin Shiva Dakshin Chavan. State of termination service. Rule of termination service. Permanent employee without a reason is void. Delhi Transport Corporation versus Mazdoor Congress. 8. Service. There could be only one norms of confirmation or a promotion of a person belonging to the same category. No junior shall be confirmed or promoted without considering the case of its senior. Any deviation from the principle will have a demoralizing effect of service apart from being contrary to the Article 16 of Constitution, where a High Court directed that the employee can confirm with the reference to the particular date, and because of the faulty implementation of High Court order, he is given a promotion and superseding many of its superior, even though he is eligible, suitable for the promotion given to him being totally unjustified and arbitrary. The government should rectify the same and refix the seniority and consequently revert them. Bal Krishna's Delhi administration. Scheduled caste. The denial of benefits to migrating members of scheduled caste and scheduled tribe does not violate Article 14 and Article 19. State of Maharashtra Union of India. Scope of Article 14. Scope of Article 14 is a positive concept. Nobody can claim equality in illegality. Nobody can claim equality in illegality. Uttar Pradesh State Sugar Corporation is Santi Raj Singh. Article 14 is to understood the light of the directive principle in Shaukhni Union of India, AR 1993. Article 14 guarantees equal treatment to a person who is equally situated. Government of Andhra Pradesh vs. Maharashi publishes power granted by a person can be abused and cannot merely be ground to declare providing unconstitutional. Ahmed Noor Mohammed Bhakti with the state of Gujarat. Article 14 of Constitution prohibits high class registration, not reasonable classification of purpose of registration, as long as a classification is found on the intellectual differentia which distinguishes a person or thing. It is a group together from other left out of the group. Distinguish a person or thing that which group together from other left out of the group. Differentiation as a rational nexus on the object or achievers. This arises no question on infringement of Article 14 of Constitution. Mumbai, Pune, Taxi Owner Association is the principal secretary, Ministry of Surface Transport. Service. Indian Administration Service, Second Amendment Regulation 1989, which brings about a classification of officer which is arbitrary and unreasonable, constitutionality, sham but a Union of India. And illegality cannot be perpetuated. Illegality cannot be perpetuated. The claim of regional regularization of temporary service cannot be granted merely because some other has regularized. The regulation others does not give the right to be responded. State of Uttar Pradesh with the Rakya Rani. Also, the state of Rajasthan with Dayalal. Service rules. On the questions where the service rules under the violate Article 14 when under mentioned decisions are given. Air India, which is Nargish Mizara, Sudhir Chandra Shagar, Tata Iron and Steel Company, KL Tirupati, State of Bank of India, Union of India is Tulsi Ram Patel, Workman is Hindustan Steel, Central Inland Water Transport Corporation because Baroja Nath Ganguly, OP Bhandari, which is ITDC, Leena Khan is Union of India. Air hostess and deputy chief air hostess belong to the same class in view of the duties performed by them. However, the Air India Corporation has already adopted the policy avoiding discrimination. The reputation has become the infructuous. Leena Khan is Union of India. Source of Article 14. Source of Article 14 lies in the American and the Irish Constitution. It may be mentioned in the preamble of Indian Constitution speak equality of status and opportunity of the article gives effect to the principle and the text of Constitution. In the sense, the demand of equality is linked up with the history of freedom movement in India. Indian wants the same right and privilege the British masters enjoyed in India and desire for the civil rights and implicit of the formation of a Indian National Congress in 1985. The Commonwealth of Indian Bills 1925, the clause 8 demanded inter alia equal before the law and provided especially that there was to be no disqualification or disability on the ground of only of sex. No disqualification or disability on the ground only of sex. Equality of law proven especially that there to be no disqualification or no disability on the ground only on sex. Only of sex. Along the provision that all the persons were to have equal right to use a road, equal right to use a court of justice, equal right to all other places of business or resort are dictated to the public. See the Chakrabarti Bhattacharya, the Congress Evolution, page 27. A right to equality find the places of report drawn by the Motilal Nehru, chairman of committee appointed determining the principle of Constitution of India. Karachi Resolution reiterated inter alia the right of resolution of fundamental right in economic social charge. Chakrabarti of Bhattacharya, the Congress evolution based on it. Shapru report 1945. The incorporation of proposal of Shapru committee, which lays emphasis on the minorities, which enunciate the fundamental right of the page 260 on the report, describing the fundamental right of the proposed new constitutions, is stand warning of all that when the constitution demand the export and perfect equality between one section of the community to the another matter of political and civil rights, the equality of liberty and security is enjoyed in the freedom of religion, worship and pursuit of the ordinary publication of the life. State policy, issuance of notification, issuance of circulars, use and concession of enterprise into rapid industrialization cannot be said to be against the provision of law. The parental drug India Limited versus State of Hindustan. Judiciary intervenes a state of policy designed to combat terrorism and designed to combat extremism in the order to safeguard the constitution value and goal of fundamental rights such as equality and right to life. Indeed, such expertise and indeed such responsibility vests in the judiciary. The court does not seek to interfere with the security consideration for which the exports. The responsibility lies with the executives, directed and controlled by the legislation. Nandini Sundar, the state of Chhattisgarh. Unless the policy is unconstitutional, unless the policy is contrary to the statutory provision, or unless the policy is contrary to the arbitrary or irrational or abuse of power, court does not intervene with the policy matter. Manohar Lal Sharma is Union of India. The policy decision could not be interfered with the court merely because it affects the business and interests of some private parties, where it is neither unreasonable or arbitrary or unfair to render the policy irrational and unconstitutional. Panchanan Shahu, State of Odisha. The policy decision is to be interfered with. The policy decisions on the interfered with them when the policy decision can be interfered with when it's found to be arbitrary. Mrs. Mangalam Organics Limited, Union of India. Tax exemption. The Supreme Court has upheld the validity of Section 1010C in the Income Tax Act 1961, which grants certain tax exemption to employees in the public sector who retire voluntarily. The objection was raised against the provision of Shakshikan Lakshman Kala, which is Union of India, on the ground that Article 14 has been violated, but it was held that the rational nexus between legislation and objective number of a public sector undertaking who has formulated this a scheme of qualitative requirement and Finance Act 1981 and introduced the scheme to exempt payment received by them. According to the approval scheme and compensation package in the public sector in such a low is much lower that as a private sector undertakes. According to the approved scheme, compensation package in public sector is much lower than the private sector undertaken or for the reason discrimination on justified. Moreover, one of the affection of the public sector were surplus staff, which were to be streamlined. The scheme is ultimately beneficial to the health and prosperity of the public sector. Kerala Hotel Restaurant Association, State of Kerala. Jahangir Batuksha is Union of India. PM Ashwath Narayanam Shetty, State of Karnataka. Federation of Hotel and Resident Association of India is Union of India. Hindustan Paper Corporation is Government of Kerala. Adi Shetty International Airport Authority of India. Income Tax Office with Yan Takin Roy Rambe. JK Jutta Income Tax Officer, Salary Vs Assam, Lawrence Singh Shetty. Hindustan Antibodies is Workman. State of West Bengal is Union of India. Pannalal Binjraj is Union of India. Ye Tangal Kunjud Musalari versus M. Venkatachalam 14. Registration was chosen to method taxing if not an arbitrary. Kerala out as Kerala. Policy clause. A policy clause is a tender issue unless it violates fundamental right. Cannot be termed as an arbitrator. JSW Infrastructure Limited versus Kakinda Seaport Limited. Since the basic requirement of Article 14 is fairness and action of the state, the norm specified in the tender would be within the domain of executive and it is shown in the norm, and malicious intended form and benefit of individual will be treated as a valid form. Electric Contractor Association of Maharashtra, Mumbai City, which is City Industrial Development Corporation of Maharashtra. Procedure adopted by the tendering authority is fair and just and reasonable. In absence of the specific malfeasance and grant of exemption for any essential condition of tender, authority has acted within the authority. Such cannot be constituted either as a relaxation or violation of tender construction. R. Ramachandra Reddy, State of Telangana here. Taxation law. In the manner of taxation, the code permits great latitude in the registration. Registration can be made reasonable, discrimination, and made a choice in respect of districts, objects, persons, methods, and even rates of taxation. Mafaltia Industries Union of India. The cancellation of benefit and concession rate tax available to tourist buses cannot be said to be discrimination. Cancellation benefit of concession rate of tax been available and tourist bus cannot be said to discrimination. Sharma Transport. Cancellation of benefit of a concession rate of tax be available. Okay, the Sharma Transport is government of Andhra Pradesh.